We are going to start ownership, which will take much of the discussion under property law. So, the provisions dealing with ownership are 11.1 to 10.57. All these are about ownership. And here, when we talk about ownership, we are talking about individual ownership. Okay, that is the first important point. When we talk about ownership under these provisions, we are talking about individual ownership. That means there are different types of ownerships. Okay, it's not only individual ownership. We have different types of ownership. Individual ownership is one, as we are going to consider. So, joint ownership is there, common ownership is there. There are different types of ownership. Okay? Common ownership or even communal ownership. Different types of ownership. You can enumerate. State ownership, public ownership, or state ownership. Types of ownership. And the type of ownership depends on who is exercising the essential elements of the right of ownership. Who exercises those rights to which an owner is entitled. Okay? These types of ownership, as I've said, in the first place, here we are going to deal with individual ownership. And why is it individual ownership? Because there are different types of ownerships, and here we are concerned with individual ownership. What are different types of ownership? Individual ownership, joint ownership, and joint ownership. We have it under 1258 and the following. Okay, those provisions deals with different type of ownership. That is joint ownership. So there are different types of ownerships. 1250. And the following here it is 56. So, if you talk about individual ownership, we are talking about the situation where all the right to use the thing, the right to collect the fruit of the thing, and most importantly, the right to dispose the thing, and the right to exclude others. Okay, the power to exclude others from using or having any kind of contact with the thing, where all these rights and privileges. Okay. All the rights and privileges of ownership are vested in a single individual, we call it individual ownership. Okay? Where all these rights and privileges, when I say privilege, it is, when you talk about rights, the essential elements that we are going to talk about is the right to use, the right to collect fruit, the right to dispose. These are essential elements of ownership. Okay? These are the essential elements of ownership. But this is not the only content of ownership. There are other contents of ownership, which we call as privilege. Okay? Privilege or prerogatives. Prerogatives or privilege. And so, ባለቤት ነው ከተባለ መጠቀም ወይ ደግሞ ነገሩ ፍሬ የሚሰጥ ከሆነ ፍሬውን መሰብሰብና ማስተላለፍ ብቻ አይደለም ያለው። ከዚህም በላይ ማድረግ ይችላል ሆነ አይደለም። ሌሎች ሰዎች እንዲጠቀሙት ወይ እንዳይጠቀሙት መከልከል ወይ ማገድ ወይ መፍቀድ ስልጣን ነው። It is a prerogative. Allowing others to use, collect fruit of the thing, or excluding others. Okay? Excluding others. Defending his right of ownership against all third parties in the world. That is another prerogative. Okay? He is considered as a possessor. He has a right to use force as an owner to protect. He has a right to bring action. So defending his right of ownership. That is another power of an owner. Transferring the thing or allowing others to transfer on his behalf. ሌሎች እንዲያስተላልፉለት መፍቀድ. That is another prerogative. Okay? So there are other powers. ስልጣኖች አሉ ማለት ነው። እነዚህ መብቶች ናቸው በመሰረቱ። ከነዚህ መብቶች በተጨማሪ ስልጣኖች አሉት አንዱ ማለት ነው። So that's what we call the rights and privileges or prerogatives. So if all these rights as well as the privileges or prerogatives are collectively given to a single individual, we call that type of ownership as individual ownership, where all these rights and the prerogatives are exercised just by one individual. We call it individual ownership. Where those rights as well as prerogatives or privileges are exercised by two or more individuals at the same time against the same thing, we call it as joint ownership. ሁለት ሰዎች አንድ ላይ ሆነው መኪና ቢገዙ መኪና ቢገዙ በዛች መኪና ላይ የመጠቀም መብቱን በተመለከተ ሁለቱን ነው። regarding the right to use the thing, they are two. Regarding to collect fruit, they are two. Regarding to dispose, they are two. Regarding exercise of all these rights, the people are two. Okay? So all these rights and privileges are vested in two or more individuals at the same time against the same thing. At the same time against the same thing. At the same time, የሚባለው ለምሳሌ ይሄኛው አብሮ ገዙ አብሮገዙና ለሁለት ዓመት ሙሉ በሙሉ የኔ ናት መኪናዋ ከሁለት ዓመት በኋላ ደግሞ ላንተ ሰጣለሁ ብሎ እንደዛ በካፈሉ ጆይንት ኦነርሺፕ አይደለም እሱ is an individual owner for 2 years but he has an obligation to transfer to another person after 2 years, so that is not joint ownership. At the same time exercise ያደርጉ joint ownership የሚባለው ማለት ነው። አብሮ ገዝቶ መኪናዋ ላይፍ ስፓን ወይ ደግሞ አገልግሎት የምትሰጠው reasonably ለ8 ዓመት ነው ቢባል የመጀመሪያው 8 ዓመት I am the owner and then after 4 years I have an obligation to transfer to you. ለሌላ ሰው አልሸጥም ለሌላ ሰው አላስተላልፍም ላንተ ማስተላለፍ ከሆነ ኮንትራክት ተፈራረሙና will be obliged to transfer to the second person after 4 years. That is a promise of sale, another form of contract ማለት ነው እንጂ it's not joint ownership in that case because they are not exercising all these rights and privileges at the same time. Joint ownership የሚባለው እነዚህ ሁለቱ at the same time እነዚህ ሁሉንም at the same time against the same thing. Okay? It should be against the same thing at the same time. Then we call it joint ownership. It may be created by law, it may be created by contract, it may be created by will of succession, in succession, it may be created in different forms. Joint ownership. And the common ownership is different from that. Okay? Common ownership, the type of ownership you have between husband and wife, that's not joint ownership. Okay? Joint ownership and common ownership are different. They are not essentially the same. Do you think joint ownership and common ownership? Is the joint ownership clear? Essential. Joint ownership, is it clear? So common ownership between husband and wife. That is the best example, okay? The ideal example of common ownership. Between husband and wife, joint ownership I have. Okay? From the very beginning, joint ownership should have some source, okay? It may be the law, as I've said, it may be the contract, or it may be a will in succession. There should be somebody who agreed to create. It may be the law, or it may be the testator, or it may be the parties. But common ownership, it's just created by law because the two parties are living in marriage. They don't have to agree, okay? The parties don't have to agree in marriage. Yeah? Common property እንዲፈጠር ወይ መስማማት ያስፈልጋል በግልጽ ተነጋግሮ ያስፈልጋል አስፈልግም እኮ it's just if you live in marriage it will be created በቃ valid የሆነ marriage conclude በመደረጉ common property will be created. Can they stop creation of common property? በስምምነት ማስቆም ይቻላል? እኛ አብረን በምንኖርበት ጊዜ ሁሉ common property በመሃላችን አይፈጠርም። እኔም ሰርቼ የማመጣው የግሌ ነው አንቺም ሰርተሽ የምታመጪው የግልሽ ነው ብሎ ይቻላል? እንደዛ አይነት ኮንትራክት ቢመጣላችሁ እንዴት ብላችሁ ነው የምትወስኑት? ስማ in case of divorce Is it in accordance with the importance or the value that we attach to family as a fundamental unit of the society? No. So they can't stop creation of common property ማለት ነው። common property በስምምነት እንዳይፈጠር ማስቆም አይቻልም። So it is not within the control of the parties, common ownership. As long as the marriage exists, common property or common ownership of property continues to exist. They can't stop it at any time ማለት ነው። በቃ በጋብቻችን እንቀጥላለን። ከዛሬ ጀምሮ ግን የጋራ ንብረታችንን ተካፍለን ለብቻችን አድርገን ነው there is no common property። በጋብቻው ግን እንቀጥላለን አይቻልም። It can't be like that because common property is the basis for marriage itself, for sustainability of the family itself. The family lives on the common property. So they can't stop it. It's not within the control of the parties. But joint ownership, even if it is created by law, even if it is created by succession, it can be terminated. There are only some requirements. We will see that after this. There are only some requirements. If you fulfill that requirement, you can terminate it at any time. Joint ownership. But common ownership or common property of husband and wife is not amenable to this termination or division or partition as long as the marriage exists. So common ownership is different. Public ownership, it is when, like the type of ownership that exists in Ethiopia at the present time against land. Okay? Land ownership at the present time is vested in the public, in the peoples, the nations, nationalities, and peoples of Ethiopia, it says. So it is a public ownership. No specific organ claims the right of ownership. Public ownership ከተባለ ደግሞ it is just vested somewhere. There is no specific organ or a single person that claims the right of ownership in this type of ownership ማለት ነው። Public ownership or state ownership. The state exercises the right of ownership on behalf of the community. The state is not the owner. Forgetting what our constitution states, it's vested in the nations, nationalities, and peoples of Ethiopia and the states. Whether the state is the owner, it is something confusing. But public ownership, it is vested in the community or in the public in general, and there is no single organ or single individual who claims the right of ownership. It is exercised collectively, and the state will be the representative of the community in exercising that right. Communal ownership, if you go to, for example, pastoralist communities, or even in the agricultural community, there are some lands left for some kind of, for grazing, for example, or for field to play for their children, or where to keep some of their animals. There are some lands which are left vacant. Agricultural community must go. ከብቶችን የሚታሰሩበት or የሚውሉበት or ልጆች የሚጫወቱበት or for whatever reason ተብሎ የሚተዉ ቦታዎች አሉ in agricultural community. And in pastoral communities it is very known. እና እነዚህ የሚተዉ ቦታዎች while other land or other similar property is owned and used individually, there are some parties of the same property, land, በተለይ ይተውና የጋራ መብት የጋራ ጥቅም ለጋራ ጥቅም ይውላሉ። communal ownership የሚባለው ማለት ነው። Where certain community, okay, not the nations, nationalities, or the public, or the Ethiopian people in general, but certain community, okay, certain group. It may be a clan, or it may be a group, or it may be a group, or just certain group exercises the right of ownership against something in common. That's what we call communal ownership ማለት ነው። ስለዚህ የተወሰነ ግሩፕ አለ ownership claim የሚያደርግ, and that is different from joint ownership. And so there are different types of ownerships. That's the point. There are different types of ownership, and here we are concerned with individual ownership only. Individual ownership only ማለት ነው። You forget about the others, and we will be talking about individual ownership only. And regarding individual ownership, regarding the definition of what is individual ownership or what is ownership. So we just use the term ownership and implicitly it is individual ownership. So the definition of ownership, how do you define ownership, or do you have any idea how ownership is defined as a property right as well as a concept? Okay? Like what we said for possession. We said that possession sometimes is considered as a concept, sometimes it is considered as a right. So like that. Ownership also maybe can be considered as a concept and at the same time as a property right. So what comes into your mind when you talk about ownership? After comma, the owner may use his property and exploit it. How? How? As he thinks fit. As he likes ማለት እኮ ነው እንደመሰለው as he thinks fit, as he thinks appropriate. So do you think property right is a property right that entitles an owner to do whatever he likes to do with the thing? Right. It's an ultimate right that the person may have against something. What does the 1204 say? 1204 definition. Says what? Definition says, so ownership is the widest right that may be had on a corporeal thing, it says. It's not only corporeal thing. We can have ownership also against incorporeal things from the beginning. That doesn't seem to be reasonable. It is the widest right that a person can have against a corporeal thing. No. Why not incorporeal things? We've been discussing about incorporeal things, and there are cases where the law refers to incorporeal things. Yes. All those provisions, 11, 28, 29, they are giving us examples of incorporeal things, things which are not visible, things which do not have physical existence, but which are considered as goods, as things against which we can create property rights. So there is no corporeal things. It's not reasonable. Anyway, against things of economic value, okay? Against goods. So it is the widest right. That's the definition. That's the definition. What do you mean by the widest right? How wide is ownership? Can we see anything from others? Reading the two together. 1205 plus 04 plus 05. Can we read together, the two together, and read out how much ownership is wide? It says that ownership is the widest right. And actually other civil codes, okay? The French civil code as well as German civil code and even the Louisiana civil code, okay? Louisiana civil code. This is civil code, one of the oldest codes, right? You know? Louisiana civil code below መጽሐፎች ምናምን ስታነቡ ብዙ ጊዜ ሪፌር ይደረጋል። Oldest code ስለሆኑና ከሆኑት አንዱ ስለሆነና and at the same time this is the state in United States of America which is the only civil law country. Have you ever discussed about this legalist or something? Louisiana state, Louisiana አንዱ state ነው ከአሜሪካ ስቴቶች አንዱ state ነው። Now this is the only civil law state ማለት ነው from all others. America has a common law system መሆኑ ታውቃላችሁ። So while America in general is a common law system, Louisiana state follows the civil law system. So it has one of the oldest civil laws. And whenever there is a discussion, historical discussion or some discussion on concepts like ownership, like possession, all others. And when we discuss about these concepts in civil law system, one of the background is the Louisiana Civil Code, the Roman law. Now, ከሚባሉት ውስጥ አንዱ ነው። እንደዚህ ሲቪል ኮድ which is still alive and still working. So it is the only state that follows civil law system as opposed to the common law system which prevails all over the other states of America. So the point is all the other civil courts, okay? The highest right that one can have against a thing, okay? The highest right that a person may have against the thing, and that is why ours also, our civil code also says, the widest right, okay? The ultimate right, as he has said. Now, 10 days, it's the ultimate right. The widest right, the highest right, an exclusive right. That is how they try to define. Otherwise, there is no just a single statement or uniform across the world definition of ownership. Okay? So it's better to focus on the contents of ownership, and especially how ownership is different from all other property rights. And what are the contents of ownership? That gives us better idea about ownership rather than just trying to define it in a single word or in a statement. The content of ownership, or what an owner can do with respect to the thing against which he has the right of ownership. Okay? That is an important point to consider. And comparing ownership with other property rights. Okay? Other property rights. We have usufruct, which is very much close to ownership. Usufruct, lease, mortgage, all others, possession, all other property rights. So it's better to compare the two and consider also the content of ownership. So regarding the content of the element of ownership, different books or different materials refer to 3 elements. The right to use the thing. Okay? That is the first right to which an owner is entitled. The right to use the thing. So the right to use the thing is the right to use the thing physically. That is how the right to use starts. Whatever use the thing gives money. That's the right to use. But importantly, is there any difference between the right to use for an owner and the right to use for a lessee, for example? The right to use for an owner and the right to use for a structure. That's an important point. Is there a difference between the right to use as it is exercised by an owner and the right to use as it is exercised by a structure, for example? Can you think of any difference? Any evaluation? የምን የመኪና እሱ ተጠቃሚ ነው። ዩሱፍራክቸሪ ለ5 ዓመት ተጠቀም ተብሎ የተሰጠው መኪኖቹ አንድ አይነት ናቸው፣ ሚኒባስ ናቸው። እኔም እነግድበታለሁ፣ እሱም እነግድበታል። or whatever I'm using it, he is using it. Is there a difference between this uses between me as an owner and him as a structure? መጠቀም እንደተመለከተ መጠቀም ስንል እኮ መጠቀም ኢንዴፊኒት ዩዝ ኤንድ ሊሚትድ ዩዝ የሚለው አይደለም እንዴ? እኔ እናንተ ባለው የታይም ሊሚት ልዩነትማ አለ እንጂ በጣም ትልቅ የሰማይና የምድር የሚያክል ለዛው በየቀኑ ለምሳሌ እኔ ኦነር ነኝ። ማን ነው ከጠዋት ጀምሬ እስከ ማታ 12 ሰዓት ብቻ ተጠቀም የሚለኝ? ምሳ ሰዓት ላይ እቺ መኪና መንቀሳቀስ ያለባትን መቆም አለባት የሚል የማታ ከዚህ አዲስ አበባ የሚሰሩትን መስራት አትችልም መኪና የሚል ይቆጥቶ ያ ስራ ካልተከለከለ በስተቀር የነን መኪና እንደዛ የሚገድባት ሰው አለ? እኔ ባለቤት ከሆነ አንተ ግን እኮ ባለቤቱ ሊገድብ ይችላል። እዚህ ሀረር ውስጥ ብቻ ነው የምትጠቀምበት፣ አዲስ አበባ አትሄድበትም። መጠቀም መብት ነው እያወራን ያለው። ሊገድብ አይችልም። ባለቤቱ እየሰጠ ሰው የመጠቀም መብት ለኦነር ሲሆንና ለሌላ ሰው ሲሆን ልዩነት አለ። there is a big difference.
that of the right to use by the owner is indefinite. As long as the thing gives use ማለት ነው ጥቅም እስከሚሰጥ ድረስ it is indefinite. An owner has indefinite right to use. But other people also may have the right to use. Let's see, structure and others they can have the right to use. ተውሶ መጠቀም ይቻላል። ግን የሌሎቹ የመጠቀም መብትና የኦነር የመጠቀም መብት there is an essential difference because that of an owner is indefinite. When you talk about the right to use for the owner, we are talking about indefinite use ማለት ነው. That means as long as the thing is useful ማለት ነው. ይቺ መኪና አርጅታለችና አሁን በቃ መቆም አለባት ብሎ ከዛሬ ጀምሮ አቁም የሚለው ሰው አይደለም እንዴ? So it is indefinite as long as the thing is useful ማለት ነው. And while we are talking about the right to use for others, there can be different limitations. Okay? There can be different limitations. መኪናዋ የኔ ከሆነች ሚኒባስ ለምንድነው ሚኒባስ ናት እና በቃ ጓደኞችን ለማመላለስ ከዚህ አረን ለመሄድ ወር ስራ ቦታ ለመሄድ ብቻ ሊጠቀምበት ይችላል። አይ ብዬ ደግሞ ገንዘብ ሲያንሰኝ ቀይራት ለሱፐር ሰርቼ እንትን ላይ እንድትሉ ሊያደርግ ይችላል። ገቢም የሚያስገኝ ስራ እንድትሰራ ማድረግ ይችላል። 5 ዓመት ተጠቀምበት ተብሎ የተሰጠኝ ከሆነ ግን ባለቤቱ ለራስ መመላሻ ብቻ ነው እንጂ ለንግድ አድርጌ መኪናንማ አጨረሳትም ለንግድ አይደለም ራስ ብቻ ነው ብሎ ድግድ while I have the right to use የተሰጠኝ but it can be limited. The mode of using, the time of using, all this can be limited when we are talking about the right to use by others. Okay? The mode of using the thing. Okay? The mode of using the thing. The time for using the thing. The time limit for it. There is a time limitation for the right to use by others. But for an owner, there is no time limitation. There is no limitation regarding the mode of using the thing. The only limitation is the limitation imposed generally for public purpose, for the interest of others. ያ ማለት indefinite ነው ማለት ምንም አይነት limitation የለበትም ማለት አይደለም. There are limitations obviously. There are limitations. እንደምንድነው 1205 ምን ብሎ ነው የሚጀምረው? 1205 አርቲክል 1 without prejudice to ምናምን ይላል አይደል? So subject to the limitations imposed by law. Subject to limitations imposed by law, an owner can use his thing as he thinks fit. So there are limitations. There are limitations which are imposed in order to protect public interest. There are limitations which are imposed in order to protect the right of others, other individuals. Okay, individual rights of others and public interest. These are the most important source of limitations. Not only against the right of ownership, against other property rights also. So there are limitations which arise from this. እና ባለቤት ነኝ የመጠቀም መብት አለኝ ብዬ እኔ እቺ መኪና መንገድ ላይ ስንዳ በግራ በኩል መንዳት አይችልም። there is a limitation. እኔ ናት ለፈለኩ መጠቀም እችላለሁ። ስለዚህ በግራ በኩል ነው የምነዳው ብዬ ማለት አይችልም። after this በኋላ መኪና መንዳት አይቻልም because of the traffic regulation and because of the risks and accidents. after this በኋላ መንዳት ከተማ መውጣት አይቻልም የሚል ትራፊክ ደንብ ካለ የኔናትና ምን አገባችሁ እኔ ለሊቱ 6 ሰዓት ተነስቼ እነዳለሁ ማለት አይችልም። there is that limitation. That is a general limitation against all ownerships, not against me. All the owners of similar things may be subjected to restrictions while using the thing or collecting the fruit or disposition. There are restrictions. That's a general restriction. It's not specific to me or to my ownership. So otherwise, if you are talking, the same thing applies to the right of collecting fruit also. Okay? Others also can have the right to collect fruit. The right to collect fruit is not limited to owner. Okay? It doesn't require to be an owner to collect fruit from something. ሌሎችም ሰዎች okay? Leasing or mortgage or restructuring can collect fruit of something without being an owner of the thing. ሌሎች ሰዎችን ባለቤት ያልሆኑ ሰዎችን ፍሬ መሰብሰብ መብት ሊኖራቸው ይችላል። As you have said, if a house is given in usufruct for 10 years for an individual, then the individual can use it himself, or he can lease it out to somebody else, and he can collect the rent. That is a fruit. Rent is a fruit. Or I may be given a farmland, okay? A coffee farmland for 5 years. I'm not the landholder. I'm not the owner of the coffee trees. But I may be given the right to collect the fruit. And then I collect fruit and use it for different purposes. So somebody may have the right to collect fruit against something without being the owner of the thing. But collection of fruit by the owner and collection of fruit by others is still different. Okay? It's still different. ፍሬ መሰብሰብን በተመለከተ ያው ኦነሩም ይሰበስባል ያ ሌላም ሰው ይሰበስባል ብለን ሊሚቴሽን ልዩነት የለም ማለት አይቻልም። ምክንያቱም ከአንድ እርሻ ላይ ቅድም እንዳልነው ከዛ የቡና እርሻ ላይ 100 ኩንታል የሚገኝ ከሆነ ኦነር ከሆነ የሚሰበስበው ሰው ኦነር ከሆነ ከመቶ ላይ የኛ ያህል ለእንትና መስጠት አለብኝ የሚባል ነገር አለ እንዴ? If he is the owner, is there any such limitation? There cannot be such limitation. Tax መክፈል አለብኝ, that's different. ይህ ከምታገኘው ላይ 100 ካገኘ 10% or 20% for Mr. X or some organ መስጠት አለብኝ ብሎ ግዴታ የለም ኦነር ላይ። He will collect as much fruit as possible from the king ማለት ነው. As much as it gives fruit ማለት ነው. But the right to collect fruit by others, this fracture, for example, it may be restricted. ከምታገኘው ላይ 10%ቱን ይዞታዬ ንብረቴ ሰላም እንዲሆን 10%ቱን ለእንደዚህ አይነት ህፃናት አሳዳሪ ምናምን ወይ ህፃናት አሳዳጊ ድርጅት ምናምን ትሰጣለህ። እንደዚህ 10%ቱን ለእንደዚህ አይነት ኦርጋን ትሰጣለህ ብሎ ኦነሩ ሊሚቴሽን ሊጥልበት ይችላል። It can be subject to different limitations, the right to collect food, like we have said for the right to use money. So it can be subjected to different limitations. Collection of fruit also, collection of fruit. It is time bound. Collection of fruit by others is time bound, like the right to use. But by owner, it's not time bound, it's indefinite matter, still subject to the restrictions imposed by law. So, but still, this right to use, the right to collect fruit, can be exercised by others also who are not owners. So in other words, to some extent, this rights of an owner may not enable us to create full distinction between what ownership is and what other property rights are. Because this right to use and right to collect fruit can be exercised by others also. Okay? Others, I mean, who are not owners ማለት ነው። ባለቤት ባልሆኑ ሰዎችም ኤክሰርሳይዝ ሊደረጉ ይችላሉና ኦኬ he is an owner, he is not an owner ብለን this rights may not enable us to distinguish between who is an owner and who is not an owner in some circumstance. Because me as an owner can exercise the right to use against something and he also can exercise the right to use the thing against the same thing. ስለዚህ እኔ ባለቤት መሆንና እሱ ባለቤት አለመሆኑን ዲስቲንጉሽ ለማድረግ ብዙም ላያገለግሉን ይችላሉ። It's only when we go to detail that we create a distinction between the right to use by an owner and by others. ስለዚህ አንድ ሰው ባለቤት ነው አይደለም የሚለውን ነገር ለመለየት ownershipን ከሌላው ዲስቲንጉሽ ለማድረግ this may not be as such helpful because they can be exercised by people who are not owners. This two rights ማለት ነው. So the essential element of ownership which distinguishes between who is an owner and who is not an owner is the right to dispose. Okay? The right to dispose ማለት ነው። መሪው መብት ማለት ነው። መሪው መብት from all others. ሌሎቹ ተከታይ ናቸው። The essence of ownership. Okay? The essence of ownership is the right to dispose. The essence of ownership is the right to dispose. It is a clear point of distinction between the right of ownership and the other property rights, the right to dispose. Clear point of distinction. The right to dispose. Because it requires to be an owner to dispose something. Disposing means what? Disposing means it's just transferring. Transferring in different ways, man. Alienating the thing, okay? Alienation. Alienation. Disposition. Okay? Disposition. Alienation. Transferring money, the right to transfer. Nobody else can exercise this right except an owner man. In all circumstances, it requires to be an owner, or it requires permission from an owner to dispose something. Okay? And so, and the it may be through contract of sale, or it may be through inheritance, or through donation, whatever. These are the principal forms of disposition: sale, inheritance, donation, and there can be others also. But these are the principal ways of disposing something. So in order to dispose something in any of these modes, it requires to be an owner, or it requires permission from an owner. And so, and the ነገር ለመሸጥ ወይ ባለቤት መሆን አለበት አይደል? ወይ ባለቤት መሆን አለበት ወይ ደግሞ በባለቤቱ ውክልና ተሰጥቶ ፍቃድ ተሰጥቶ ሰው መሆን አለበት አይደል? There is no any other way that you can dispose legally, I mean. Either you have to be an owner, or you need to have permission of the owner, agency from the owner, representation from, you have to represent the owner. There is no other way to dispose something. You see? It requires to be an owner. Or ባለቤት መሆን አለበት ወይ ደግሞ ባለቤት ከጀርባ መቆም አለበት። አንተ ስፔሲፊክ ስፔሻል እንትን ስላለ ኤክስፐርቲስ ስላለ ዲስፖዚሽኑ ላይ ለአንተ ሊሰጥ ይችላል ኦነር ማለት ነው። ሽያጭ ላይ አንተ ሽያጭ ባለሙያ መደራደር ኦር ያንን ነገር በተመለከተ አንተ ኤክስፐርት ስለሆንክ then we give you the authority to dispose it on your behalf. But still you are there. The owner should be around. I mean through agency. So in all circumstances, disposition requires to be an owner. So that is a clear indication of what is an ownership and who is an owner. That's one thing. It requires to be an owner to dispose. And disposition is a clear indication of ownership because that is the right which an owner can exercise while he is alive or even after his death. Disposition. That is the right that he can exercise while he is alive or even after his death. Actually, after death, he is not going to exercise it personally. It is through the mechanism of law. It is through the will that he leaves behind. He can leave a will behind, intestate succession, or even in case of intestate succession, the law is there to dispose the thing on behalf of the owner. አይደለም intestate succession ምንድን ነው የሚባለው? It is intestate succession ምንድን ነው የሚባለው? Presumed will of the testator አይደለም እንዴ? Presumed will of the deceased እኮ ነው የሚባለው intestate succession. Presumed will of the deceased. Presumed will ቢኖር ኖሮ እንደዚህ ነበር የሚያደርገው እሱ ልጅን ቅድሚያ ላይ የምናመጣው ከልጅ የሚያስቀድም እንደኖረ circumstance ከልጁ ማንንም የሚያስቀድም የለም ቢኖር ኖሮ ብናገር ኖሮ ሳይናገር ሞት እንጂ ብናገር ኖሮ ከልጁ ማንንም አያስቀድምም አንድ ሰው ከዲሰንዳንት in the reasonable circumstance ከዲሰንዳንት ማንንም የሚያስቀድም ሰው የለም ስለዚህ ዲሰንዳንቶች መጀመሪያ ይምጡ ከዲሰንዳንት ቀጥሎ ደግሞ እንደዛ presumed will of the deceased ነው የሚባለው። We are still, even in case of intestate succession, we are enforcing the presumed intention of the testator, even if we don't actually know ማለት ነው። So in other words, the testator or the person, an owner, is exercising his right of ownership even after his death. That is a little bit conceptual, but it is there. And that's what the law clearly provides, 1205 sub article 2. Okay? The right of disposition. 1205 sub article 2. What does it say? The two first rights, okay? The right to use and the right to collect fruit are indicated under sub-article 1 of 1205, okay? 1205, sub-article 1 gives an indication of the first two rights, the right to use and the right to collect fruit. He can use and exploit it as he thinks fit, no, sub-article 1. That is indicating the right to use and the right to collect fruit as contents of ownership. Exploitation is just collection of fruit. Okay? Exploitation is collection of fruit using that has been indicated. 1205 sub-article 1. The owner may use it, so that is the right to use his property. Exploit it, that means collecting fruit. Exploitation is equivalent to collecting fruit. So that is the two first rights or contents, and then the right to dispose, sub-article 2. The owner may dispose of his property for consideration or gratuitously, inter vivos or mortis causa, it says. He can dispose it for consideration or gratuitously, inter vivos or mortis causa. For consideration means what? Through sale. Okay, በሽያጭ. He can dispose it through. For consideration means ዋጋ አስከፍሎ ገንዘብ ብቻ ላይሆን ሌላም ዋጋ ሊሆን ይችላል. There can be barter contract or different forms of contractual relationship. For consideration means for value. As opposed to gratuitous disposition ማለት ነው. Gratuitous disposition is disposition for free. ባለቤትነቱን የሚያገኘው ሰው የማይከፍልበት ማለት ነው። ዶኔሽን። Gratuitous disposition is disposition whereby the transferee, okay, a person who acquires the right of ownership doesn't pay anything. የማይከፍልበት ሳትከፍልበት ባለቤትነት የምታገኝ ከሆነ that is gratuitous donation ማለት ነው። So this is providing an option, okay, freedom of exercising ownership, the freedom to exercise ownership. አስከፍሎም ሊያደርግ ይችላል፣ በነፃም ሊሰጥ ይችላል። Disposition, as we have said, creates a clear distinction between ownership and others. እና disposition ውስጥ ስንገባ ደግሞ gratuitous disposition. Gratuitous disposition is a very specific point that clearly indicates who is an owner ማለት ነው። ማስተላለፍ ለምሳሌ ቅድም እንዳልነው የባለቤትነቱን ኮንሰፕት ካለን የባለቤቱን አግሪመንት ካለን if we have an agreement from the owner, if we have the consent from the owner, I can dispose something without being an owner. አይደለም እንዴ? but gratuitous disposition በነፃ መስጠት አይችልም። ነገር እሸጣለሁ እንጂ ኤጀንት በነፃ መስጠት ይችላል እንዴ? አንድ ኤጀንት ለሌላን ሰው ንብረት የሚሸጥ ሰው በነፃ መስጠት አይችልም አይደል? ይሸጣል እንጂ። በነፃ መስጠት የሚችለው ግን በጣም ኦነር ብቻ ነው ማለት ነው። So anyway, he can dispose it for consideration or gratuitously. That is one thing. And when disposition can happen, inter vivos, while he is alive, mortis causa, after his death. Okay? Inter vivos means while he is alive, mortis causa, after death ማለት ነው. You can dispose it even after his death. That's why we have the law of succession. So this is just a starting point for law of succession ማለት ነው. Mortis causa, An owner can dispose his right even after his death. ኢንተርቪው ወስ አንድ ሰው ንብረቱን ማስተላለፍ የሚችለው በህይወት እያለ ብቻ ነው። ከሞተ በኋላ ስለ ንብረቱ ምንም አይመለከተውም ብሎ ቢባል ኖሮ there is no law of succession አይደለም አይደለም there is no law of succession በቃ እያለ የተጠቀምክበት እያለ እንደፈለክ ካደረክ ከሞትክ በኋላ ደግሞ ምን አርግ ብለን ነው አንተን የምንሰማው? ለሚገባውና ለሚመለከተው ሰው እኛ እንሰጣለን ቢባል ኖሮ Do you think we need law of succession? አንተማ ሟች ነህ። በዛ አይነት ቲዮሪ አለ እኮ theories of succession ላይ እኮ ቲዮሪ አለ እኮ እንደዛ የሚል why we give any power to a dying person ሞት ሰው is no more responsible to the community እሱ ከሞተ በኋላ ልጆቹ ተጎዱ ተበደሉ የሚበሉትን አጡ ተቸገሩ ኦር ተመችቷቸው ኖሩ ንብረቱን ተጫወቱበት ተዝናኑበት ጨፈሩበት ምንም የሚያውቀው ነገር የለም ያ ንብረት ደግሞ እሱ ከሞተ በኋላ ልጆቹ ሰልፍ ሰፊሸንት ሊሆኑ ይችላሉ ለምሳሌ ሰልፍ ሰፊሸንት ሊሆኑ ይችላሉ ከልጆቹ በላይ በጣም የሚያስፈልጋቸው ሌሎች ሰዎች ሊኖሩ ይችላሉ እኛ መወሰን ለምን አይገባንም እሱ እስካለ ድረስ እንደፈለገ እንዲያደርግ ወሰንለት ደግሞ ከሞተ በኋላ ምንድነው ተብሎ ያ አርጉመንት ያ ቲዮሪ እኮ አዶፕት ቢደረግ there is no law of succession so mortis causa ብሎ መኖሩ it is a basis for law of succession an owner can dispose his property even after his death okay the right of disposition is not limited to while you are alive you can exercise it through other mechanisms the law of succession or tested succession by your own will by your own document below እንደዛ mechanism የተቀመጡት because disposition extends to after death of the person also so these are just essential contents of ownership it doesn't matter whether the ownership is exercised by individual joint ownership or common ownership these are essences of ownership okay so these are the essential contents of ownership the rights which are contents of ownership but as you have said ownership is not limited to these rights the power to exclude others okay the power to exclude others one of the most important powers the power to exclude others from using the thing collecting the fruit or the power to allow others okay ማንም እንዳይደርስበት ብሎ መከልከል የፈቀደውን ሰው ደግሞ መርጦ እንዲጠቀም ማድረግ that is a power that can be exercised by a person who is the owner the power to exclude others not only the power to exclude others the power to defend his right okay that's also power he can claim his right against all other third parties in the world all third parties in the world right in one so there are different powers that arises from ownership not only rights but there are still obligations that we will consider in the future and another important point if you have any question on this point is you can say to your audience otherwise you have to go ገንዘብ ነው ገንዘቡ የሱ ነውና ባለ መቶ ብር 50,000 ብር በዛ ይበል አሪፍ ነው እና 50,000 ብር አንድ ላይ አስሮ በፕላስቲክ አስሮ አንድ ሰው ቢያቃጥለው ይቻላል ወይ ነው ቤትስ ፕሮፐርቲ ሰባውት ሙቨብል ፕሮፐርቲ ምን ማድረግ ይችላል ምን ማድረግ አይችልም ነው ኦኬ በዚህ ወሰናል እንደ ፎሎግራፍ and nowhere regarding disposition all we have is 1205 for that matter ሰባት ግድ እና ማቃጠል አይችልም what are the modes of disposition allowed and what are the modes of disposition prohibited where should disposition stop that's the question now ያለነው ነገር ምንድነው where should the disposition what constitutes disposition እና ሁለቱም ሳይድ አርጉመንት አለ አንደኛው እያልን ያለ ነው there should be some kind of limitation. Okay? Disposition, we are giving him a right. አይደለም እንዴ? We are giving him a right. While disposing your right, it should be for a purpose. አይደለም እንዴ? መብት የምንሰጠው እኮ የሆነ ፐርፐስ ነው። የሆነ ፐርፐስ ተጠቅምበታለህ። የሆነ ፐርፐስ ታውለዋለህ ብለን አይደለም የግድ ነው እንድትሉ አይደለም። argument, I'm just talking of an argument. An argument which says that the disposition should have limitation. Okay? The disposition should have limitation. What is the limitation? We are giving you this right so that you will use it for some purpose. And if the mode of disposition is purposeless, that should not constitute disposition. ማቃጠል ማውደል ምናምን ምንድነው ፐርፐዝ? mental satisfaction. Can it give mental satisfaction? Do you think it gives mental satisfaction? አስቸግራው በየቦታው እየቆመች ነዳጅ ኮንሰምፕሽኗ በየጊዜው እየጨመረ አናቱ ላይ ወጣበት እንዳቃጥልሽ mental satisfaction ይሰጣል። Anyways, purposeless መሆን የለበትም disposition. It should be for purpose. That is the argument. It should be for purpose. This is a right. We are giving him this right as well as power which we are not giving to anybody else except him. Okay? ለዛ ሰው ብቻ ብለን እየሰጠን ያለ ነው መብት አለ ለሌሎች ሰዎች ያልሰጠናቸው ስትራክቸር ለሞርገጅ ለሌስን ምናምን ሌሎች ፕሮፐርቲ ራይት የሚሰጣቸው ኦር ብቻ ብለን እንደ ልዩ ፕሮቴክሽን የምንሰጠው ይሄ መብት it should be for purpose. እና if the disposition is for no purpose, it should not be legally protected. It should not have legal recognition. That's one of the argument. And the other, one way or the other, there are people who have contributed at individual level or at community level and even at country level. There are some people who have at least indirectly contributed to the acquisition of that thing. Okay? በሞራል ድጋፍም ቢሆን በለበርም ቢሆን በገንዘብም ቢሆን ሀሳብ በማመንጨትም ቢሆን there are people. It can't be there is nobody. It is absolutely theoretical to think of somebody who can acquire this house without help or without assistance, without contribution from the community or from anybody else. Do you think? Do you think it's possible to acquire something without any form of indirect or direct assistance? No. It's very difficult to think of that kind of thing. And now there should be always limitation. That's one way of argument. The other way of argument, no, if we are giving him disposition cannot be subjected to limitation. If disposition is subjected to limitation, it's no more disposition, it's no more freedom of ownership. ብቸኛው ኦነርሺፕን ኢንዲኬት የሚያደርገው ዲስፖዚሽን ሆኖ እያለ ያንንም ሪስትሪክት የምናደርግ ከሆነ ደግሞ it doesn't constitute even the right of ownership. There is somebody else ማለት ነው. There is somebody else who is in control of the right of ownership. That is otherwise argument. If disposition as we have said is the most important expression of ownership. Okay? It is the most important expression of ownership. And if we limit or if we restrict this right, that means there should be another person who is the owner. ሌላ ባለቤት የሚባል ሰው አለ እንጂ የኛውን ሰው ኦነር ነው ማለት አይቻልም. If his right to dispose is limited in any way, if it is restricted in any way, then we better call a person who is imposing the restriction as the owner of this person. Then we መቻል So there is no provision that gives answer to this disposition. ምን ማካተት ይችላል የሚለው ፕራክቲሱ ነው መልስ የሚሰጠው እንጂ ፕራክቲሱ ነው መልስ የሚሰጠው ስንል ማን ነው እስካሁን መኪናውን የሚያቃጥል ሰው የሚያቃጥል ሰው አለ መኪና የፈለገ ለምን 10 መኪና አይኖረው የትኛው ኢትዮጵያዊ ነው እስቲ አሁን ቤቱን የሚያቃጥል? ፕራክቲሱ ነው መልስ የሚሰጠው። እንደ ቲዮሪ እናውራ ከተባለ we have these arguments on both sides. There are arguments on both sides. But practically ስናይ it doesn't seem to be something which happens in practice. ወንጀል ነው። እሱን አይደለምና የሚያዋርድ ነገር ሁሉ ማድረግ ወንጀል ነው ያስቀጣሉ። እሱ ግልጽ ነው። አንደኛ ያ የተባለበት ደግሞ አንተ እኮ you are not the owner of the currency አይደለም እንዴ? አንተ እኮ 100 ብር የ100 ብር ዋጋው ባለቤት ነው እንጂ 100 ብር እንትና የተሳለበት እንደዚህ ጦር የተቀመጠበት እዚህ ጋር ኢትዮጵያ እንደዚህ የተሳለችበት ወረቀቱ እሱ የሷ ባለቤት አይደለም እኮ አንቺ ያንን ዲዛይን ያደረገው ካረንሲውን ኦን የሚያደርገው the public the state ነው። አንተ ያቺ ኬሪ የምታደርገው ቫልዩ አለ አይደለም 100 ብር ዋጋ የሚባል 100 ብር የሚያወጣ ነገር መግዛት ኦር ማድረግ ነው እንጂ የሷ የወረቀቷ ባለቤት አይደለም። ወረቀቱ ኬሪ የሚያደርገው ቫልዩ ባለቤት ነው። እሱን የፈለከው ልታረግበት ይችላል። ግን ወረቀቱ ያንተ አይደለም። The note doesn't belong to individuals and you can't do anything. ዋጋው ባለቤት ናችሁ እንጂ ዋጋው በምንድን ነው የተገለጸው የሚለው ነገር የእሱ ባለቤት አይደላችሁ። ልዩነቱ ወረቀት ይሄ ወረቀት ምንም ዋጋ ነጭ ወረቀት there is no value attached to አይደለም ነጭ ወረቀት ያኛው ግን ቫልዩ አታች ተደርጎበታል በስምምነት ማለት ነው 100 ብር ተብሎ ተጽፎበት ለሁላችንም ተነግሮን ያው ስመጣ ልዩነቱ ያቆር አይደለም እንዴ ነጭ ባዶ ወረቀትና ብር እኮ ልዩነቱ is just የኮንሰፕሽን ጉዳይ እኮ ነው አይደለም የስምምነት ጉዳይ እኮ ነው ልዩነቱ እንጂ ወረቀት ነው ወረቀት አለ ብላችሁ የዛሬ ብር አላውቅም ነው የዛሬ ብር anyway ሌሎች ወረቀትና ብር መሃል ያለው ልዩነት ያኛው ቫልዩ ኬሪ እንዲያደርግ ስለተስማማንበት ዋጋ ራሱን የቻለ ዋጋ ከሌሎች ወረቀት የሚለየው ማለት ነው እና ያ የዛ ዋጋ ባለቤት ነው እንጂ እኛ ማንኛውም ሰው ማለት ነው we are the owners you are the owner of the value not the currency not the thing ማለት not the thing or not the good which carries that amount and that's the difference next week gives you the currency is one of the crimes against currency damaging or causing any kind of damage to the currency to the notes is illegal. You read the provisions. The next is about different modes of acquisition of ownership. So if we say that ownership is this much important, right? And by the way, ownership is also considered as the mother of all other property rights. Okay? ሌሎችም ፕሮፐርቲ ራይት የምንፈጥረው እኮ ከባለቤትነት እየተነሳ ነው አይደለም? if we say this ownership ከዚህ እየተነሳ ነው ሌሎቹን ownership ፕሮፐርቲ ራይት የምንፈጥራቸው the right to use as you have said arises from ownership maybe an owner or somebody else but there is ownership still the right to collect fruit use of right it starts from there pledge or mortgage, it starts from ownership. So all other property rights, the starting point, the source of all other property rights is ownership. So it's the mother for all other property rights. The property right ሁሉ አንድ ላይ የሚይዘው property right. That's why they call it the widest property rights. The widest property right that can give rise to all other property rights. Okay? That is the source of all other property rights. If you read 1204, you can divide it, okay? It can be divided in accordance with the law, okay? ህጉ የሚያስቀምጠውን ነገር ተከትለን መከፋፈል ይቻላል ነው። it can be neither divided nor distracted in accordance with the law except in accordance with the law ብሎ ያስቀምጣል። ፎርም ማለት ነው። ሰባት ክልቱ so it's giving an indication that it can be divided. Ownership can be divided. Can be divided means what? I hold the right to dispose. I give the right to use and collect food to somebody else, and then that person also gives it to the right to use only to another person. እኔ ቤቱ ባለቤት ነኝ። የማስተላለፍ መብቱን አስቀርቼ 5 ዓመት የመጠቀም መብት ለሌላ ሰው ይሰጣለሁ። ያም ሰው ደግሞ የራሱ መኖሪያ ስላለው ያከራየውና ለተከራይ ይሰጣል። There is still one owner. We are dividing the right to dispose, the right to collect fruit, and the right to physically use the house is being exercised by somebody else. Lessee, physically using the house. ለማደሪያ ለመገልገያ የሚጠቀመው ሌላ ሰው ነው። ፍሬውን የሚሰበስበው ሌላ ሰው ነው። ባለቤትነቱን ያስኩት ነው ዲስፖዝ የማድረግ so this right is can be divided. And it's by dividing the right of ownership that we create all other property rights, okay? So it is a source of other property rights. And now, how is it possible to become an owner of something? How is it possible to get this most important right against something? What are the mechanisms through which we become an owner of something? Okay? Modes of becoming ownership. የሚባሉት ሁለት ናቸው። acquisition እና transfer ናቸው. These are the modes through which a person can become an owner of something. ባለቤት የሚሆነው በዚህ ሁለቱ አንዱ ነው. It is from one of these two. It is through one of these two modes that we become an owner of something. Okay? Or we acquire a right of ownership against something is one of these two mechanisms. Acquisition and transfer. And there are 4 modes of acquisition. Okay? መጀመሪያ occupation በተመለከተ 1151 to 1160 occupation. You read this. Okay? Occupation. And then ሁለተኛ possession in good faith. This is 1161 to 1167. ሶስተኛ usurpation. Okay? Usurpation. This is 1168 and 69. Acquisition ማለት ነው. And then the fourth one is accession. 1170 to 1183. Okay? Acquisition. Occupation 1151 to 1160. Possession in good faith 1161 to 1167. Usurpation 1168 to 69. And then accession to 1170 to 1183. These are the 4 modes of acquisition. Acquisition is different from transfer. Now, okay, let me just say only one point about the difference between the two, and you read the articles and we'll discuss in the afternoon. So acquisition is where you acquire the right of ownership just from the law by fulfilling the requirements of the law, okay? Without a need for another owner to be there. ከማንም ሳይተላለፍልህ ህግን የሚያስቀምጠውን rules and regulations requirements በማሟላት ብቻ ህግ የሚሰጠን ከሆነ acquisition ነው የሚባለው. There are no two owners ማለት ነው, okay? There is no concern for previous owner in case of acquisition, okay? There is no concern about previous owner. Who is the previous owner የሚለው ነገር አይነሳም in case of acquisition. You acquire the right of ownership from the law by fulfilling the requirements provided for each type of acquisition ማለት ነው. እያንዳንዱ requirements አሉ እሱን አሟልቶ you just get the right of ownership by fulfilling the requirement of the law. That is acquisition. In case of transfer, as the name itself indicates, there are two owners አይደለም? Transfer means there should be transferor owner and there should be transferring owner. Okay? Transferring owner. ትራንስፈር ማለት መተላለፍ ማለት ነው። ስለዚህ የሚያስተላልፍ ሰው መኖር አለበት፣ የሚተላለፍለት ሰው መኖር አለበት። there are two owners ማለት ነው። the original owner, the transferor. the new owner, the transferee, to whom the right of ownership is transferred ማለት ነው. and this is maybe through purchase or contract of sale or inheritance or whatever. there are two owners, obviously. there are two owners involved ማለት ነው. and the right of this person, okay, the right of the transferee, his right of ownership depends on the right of the previous owner ማለት ነው. okay, it depends on the right of the previous owner. that means if there is any obligation, if there is any restriction, if there is any challenge against the right of the previous owner, then there will be question against the right of the new owner also ማለት ነው, in case of transfer, because the right of the new owner depends on the right of the previous owner. ጥያቄ ካለበት ሄዳ ካለበት እገዳ ካለበት መብት አለን የሚሉ ሰዎች ካሉ እዚህ ሰው ጋር ያለንበት ማለት ነው። then እነዚህ ሰዎች ይህን ሰውዬን ተከትሎ ይሄዱና መጠየቃቸው አይቀርም። so if it is subjected to any obligation, any restriction, the right of the previous owner, the transfer, then the same restriction, the same obligation will follow the new owner also ማለት ነው. that is what we mean by transfer. there are two owners involved, and the right of the new owner is as good as the right of the previous owner only. okay, it can't be better than the right of the previous owner. but in case of acquisition, there is no any kind of concern for the previous owner, whether the right of previous owner is defective, whether there is some obligation against the right of previous owner, some restrictions. There is no concern for previous owner. You just fulfill the requirement provided by law, and if you fulfill that, you acquire the right of ownership. It's not derivative. okay, acquisition የሚባለው ከህግ ነው የምናገኘው መብቱ። transfer የሚባለው, and then transfer is 1184 to 1187. okay, transfer የሚለው 1184 to 1187 ስለ ትራንስፈር ነው የሚያወሩት። so በእነዚህ ሁለቱ mechanism, it is through one of these two mechanisms that one become an owner of something, and you read these provisions and we will start discussing about acquisition of ownership and after